Welcome to Burns White Inside the Law, a podcast about the law and the people behind the practice. I'm your host, Jennifer Kelly, Director of Marketing and Business Development at Burns White. Many in the healthcare industry are observing a shift away from the traditional mindset that settlement is always the safest path. More healthcare defendants are choosing to aggressively defend claims through trials, driven by concerns about rising settlement values, social inflation, and the long-term consequences of paying these inflated claims. Today, we'll explore what's driving these trends, how juries are viewing healthcare providers, what defense attorneys are seeing in the courtroom, and what organizations can do to better position themselves when facing high-exposure claims. Welcome back to Burns White Inside the Law podcast. I'm your guest host today, Jennifer Kelly, Director of Marketing and Business Development at Burns White. And today I am joined by Stuart O'Neal, who is our CEO and trial attorney. Hi, Stuart. Welcome back to the podcast.
Thank you, Jen. Thanks for having me back. I appreciate it.
It's good to have you.
Thank you.
I'm going to pick your brain today.
Okay.
Essentially, what we're seeing in the healthcare industry is we're observing this shift away from, we used to do a lot more settlements. Now we're sort of more advantageous to go to trial, and sort of what that looks like, what that trend is looking like, and get your thoughts on that.
Yeah, no, and that's a really, really good question. And it's one that we're seeing a lot of right now in terms of what's really going on. We're getting demands that are just so high that you don't have a choice but to go to trial. Mm-hmm. So even if the case has some merit, and so, we may have discussed before, there are cases that we had 3 or 4 years ago that a demand was $3 million, now it's $9 million. Mm-hmm. And you're just, without really anything changing.
Interesting.
And so you have clients who are rightfully going to say, I know there's injuries, I know that we may have done something wrong here, I can't pay $9 million, I can't pay $4.5 million. We'll go bankrupt. I can't do it.
Right.
So you're going to have to try the case.
Mm-hmm.
Fine, then we can try the case.
Yeah.
And so, but what really isn't seen is that we try and do different things ahead of time. We try and mediate, which is a really good thing. Or we try to do a binding high-low arbitration, which is another ADR, alternative dispute resolution process.
Okay.
So that's what we're seeing right now. There are going to be a lot more trials. I don't think this is going away at all. I think the trend is going to be upward, another 10-20% next year of where we are now. Mm-hmm. In terms of trials, I think internally at Burns White, we've had 3 or 4 defense verdicts in a row, I think it was. Mm-hmm. We've had people on trial, since January. I mean, we have 7 or 8 trial teams just in healthcare. At any given time, I think we have someone on trial or approaching trial. So this trend's not going anywhere.
Right. Do you think providers and insurers are becoming less willing to settle cases simply to avoid litigation costs?
It's certainly a consideration. Some of these cases, what's the best way to put this? Some of these cases used to be relatively straightforward. If you just represented a doctor, a case could cost X amount to defend. And clients were okay with that. Now it's 18 defendants, it's 10 experts, and your costs are going through the roof to defend it. Mm-hmm. So is it a fact? Of course it's a huge factor.
Sure.
There's interplay between what you spend on defense costs and insurance, and I get that. So it really is case specific, but a lot of these major cases that have demands between $20 and $100 million, let's say, are now kind of litigation wars that we had not seen before.
Wow. Are there advantages? Are there advantages of going to trial when compared to settlement in certain cases?
I mean, you don't want to be seen as a small, like a soft target. Mm-hmm. So if I represent, a provider and we settle at a premium every single time, what do you think is going to happen? You're going to get sued a lot more because the plaintiff's attorneys, to their credit, they talk amongst themselves. Hey, X provider down the street will sell each case that you they don't want to go to trial, they're scared.
Right.
And they'll pay a good price too. So once that hits the street, so what you want to do is you do want to pick and choose a couple cases to actually try, to show a couple things. Number one, you're not a soft target. Number two, you have good attorneys that represent them. And three, a lot of our clients have employees that are so vested in their care that they look forward to the opportunity to talk to a jury.
Right. Defend themselves.
So, yeah.
Have you observed any changes in how insurance carriers approach settlement authority or trial strategy?
I see a lot of them now wanting to mediate earlier, and you and I think just touched on it, but in part to save costs, and in part to, mitigate risk, get a risk off their roll. Anytime you can do that, it's a good thing.
Yeah.
But I think that anytime you look at an adjuster, they're going to go through the maturations of, have we tried everything that's within our power to try and resolve it reasonably? And because remember, they report to another VP, then another VP. So everyone's going to ask the same questions. Did you do this? Did you do that? And so we really do find ourselves going through all the same things.
What's one of the biggest misconceptions about healthcare malpractice trials?
That they're a damages only proceeding, and what I mean by that is that juries are just there to assess how much is owed to the plaintiff. That's not the case. It is to determine first whether or not anything was done that caused factually the damages. If you don't prove that as a plaintiff, you don't get any damages at all. You just, by virtue of filing a lawsuit, you're not entitled to damages. That's not the way this works.
Okay.
You have to go through a whole journey of duty, breach, causation, and damages, and prove all of them.
Right.
So that is a misconception, and we actually try and tell jurors during our opening, just because Mrs. Smith filed a lawsuit does not entitle her to any type of damage at all. It's her burden at all times. So.
Interesting.
Yeah.
What do you think is harder, settlement or trial?
Trial.
Okay.
Trial, by a lot. By a lot. And look, we love the opportunity. It's not something we take lightly. We don't look at trial and say, oh man, I can't believe, this is 2 weeks, it's going to be blah, blah, blah. No, it's like we are ready to go. Because think about it. We have a client who is good enough to give us, number one, the opportunity to have the case in the first place, and number two, to take a case into a courtroom to try and defend it that many people wouldn't normally ever do, because they know that their job is on the line and there's a lot at stake. We're not talking about $2,000-$3,000 typically. What's in stake is usually anywhere from $5 to $10 to $25 million. So, there's a lot that goes into it.
Yeah. Not
So
a
trial.
decision you take lightly.
No.
Not
And
at all.
usually it's a combined decision with the carrier, with the client, with our evaluation, how we view the case, where it's going to land, the venue. There's some venues that are worse than others,
Right.
obviously.
Right.
So especially in Pennsylvania. So all that is in the mix.
Definitely factors. All right, closing out. One piece of advice to healthcare executives, risk managers, and health counsel navigating today's litigation environment.
Really good question. Communication. Always be talking about what the trends are, what the best practices are. We had a couple calls this morning with brokers, insurance brokers who place insurance with the carriers that we're close with. And they try and counsel them as well. We give the brokers tips on what to be talking about with the hospital or the carrier in terms of trends. And when you talk about those trends, and you talk about the pitfalls and the positives and the negatives, the more communication the better, because you want everything above board. You don't want anything coming out of nowhere.
Right.
This is never a theory that we've seen before. You never want to hear that. And for the most part, you don't hear that, but I would say always be talking. Always be talking.
Yeah, good advice.
Thank you.
Good advice. Well, thank you for
Thank you
taking
very
the time
much.
to talk to us today. I think it's very interesting to hear these perspectives. Really do appreciate you taking the time to
Absolutely.
speak with us. I will do a shameless plug for an upcoming healthcare seminar that we
that's
are
right.
planning for the fall. So more to come on that, but you will be speaking as well as some of our esteemed attorneys and colleagues here at the firm. So October 8th, put that on your calendar.
Great.
All right. Thank you again, Stuart. For those of you listening, please remember to like and subscribe wherever you get your podcasts.
Thanks, Jen.
Thank you.
The information contained in this podcast is considered an outline intended to be supplemented by an attorney. The information is not legal advice and should not be considered as such. Thank you for joining us. If you have any questions or comments regarding this episode, feel free to email us at podcast@burnswhite.com.